Well, good afternoon, everyone, and welcome to webinars. This one is going to cover not exactly a conventional IP topic, but a topic does cause issues and concern for a number of clients, and it's really about where brands have issues which are not simply about IP, but are about their reputation, and the reputation in a broader sense than just around trademarks. And my name is Mark Owen, and I'm a partner in the IP and media team. And a lot of my practice is about brand protection. But when it comes to reputation management issues, I tend to involve specialist colleagues. My colleague, for example, Michael Yates. Michael.
Hi everyone, my name is Michael Yates. I am a senior associate in the IP and media team, and I specialise in reputation management.
Right. So what we're going to do is run through some scenarios, but first we're going to set the scene about the different types of law which may apply and how brand owners or the tools which may be available for brand owners faced with different sorts of situations. And really, when you're looking at brands in this context, it's very much looking at brands through the prism of the media, represented there by the seagull, the brand being the shiny beetle. Don't ask me why. Where you're talking about something that goes wrong around a brand, then it's usually an issue about controlling the media, what the media says about the brand and the situation, and how quickly you can get the media to move on from it, or possibly not talk about the story at all. As I said, I'm going to talk about a couple of specific examples, but first, to set the scene a bit, brands are protected, as we all know, on this call by an array of intellectual property rights, registered trademarks, passing off being the main ones in this country, unfair competition as well in some other countries, but also you can get design protection for your brands, copyright in your logos. There's an array of things you can do if you feel that your brand is being misused by someone else, but not by just anyone else. What trademark protection in particular, or IP protection generally, is better for is against a certain range of people, in particular competitors. It's good against people who are making some kind of confusing use of your brand, and it's good against those who are taking unfair advantage of it and the notion of dilution. And there's a very useful definition, which, although it's in the context of goodwill and passing off cases, and although it's now quite an old case, over 100 years old, really, I think, sums up what brand protection from an IP point of view is really protecting. And it's Lord McNaughton's definition in the ISC and Muller case. And he said it's the benefit and advantage of the good name, reputation, and connection of a business. It's the attractive force which brings in custom. And I think the key phrase in all of this is the attractive force which brings in custom. That's what you're protecting with IP rights. It's the one thing which distinguishes an old established business from a new business at its first start. But there's some things that IP protection really isn't that good for, but which happen to brands. So it's not good at stopping things being used or brands being used in a descriptive sense. It's not good if, particularly as far as copyright is concerned, if the right in question lacks originality, or the brand in question. It's not good if the way that it's being used could be argued to be said to be freedom of speech. And it's really in those sorts of areas that some of the things we're talking about arise. A really good case, I think, which illustrates the line between what IP can do and where its limits are, is the Unilever and Griffin case, which is from 2010 and was a case that arose in the context of the UK general election that year. And one of the parties was standing in a number of seats that year was a right-wing party called the British National Party. And the person on the screen there, Nick Griffin, was the leader of the party. And for reasons which have never really been well explained, the party put up some videos on YouTube which had Nick Griffin speaking to camera with various props around him. But one of the things which appeared on the screen, as you can see, is an image of a Marmite jar, Marmite being owned by Unilever. Unexplained why that was there. Unilever were unhappy about their brand being associated with a political party, I think probably of any sort, and immediately ran off to court to get, or to apply for, an ex parte injunction restraining the use. And when they went for this, they threw everything they could at it. So they applied under 3 different bases. They applied under trademark infringement for registered trademarks. They applied under passing off, and they applied for copyright infringement. And it's very interesting how the judge approached it. And the judge was Richard Arnold, now Lord Justice Arnold, who's probably our most high-profile IP judge and extremely expert in all of these areas. And he had to consider the case without arguments being put on the other side by the BMP. He started with the trademark argument, and he said that he thought that there were considerable obstacles that were in Unilever's way, because he doubted that the use being made was in the course of trade, doubted that the use was in respect of goods or services. And without that, the use wasn't trademark infringement. So he didn't think that it would succeed in a full case, and he wasn't prepared to allow it to succeed in the injunction. What about copyright? Copyright in the label of the jar was the copyright relied upon. And here he said that on the face of it, there appeared to be infringement of the copyright and something that may be restrained by the court, though he noted that there is a public interest exception or defence to copyright infringement under UK law, but there's very few cases under it. It's a very undeveloped part of the law. But he thought there may be an argument that it could apply. He couldn't really decide there and then, but he thought that was a possibility. So I think just stopping there for a second, is a good illustration of where the limits are. Copyright won't always help you, even though the work being used is a copyright work. And the final ground, and perhaps the ground in the end which is the strongest for Unilever, was passing off. There have been some comments on the YouTube video underneath it, which suggest that people might have thought that Marmite was for some reason sponsoring the BNP. And based on those, he was prepared to hold that there was an arguable case of passing off, and he granted the injunction, both on that and he's prepared to grant it on the copyright basis. But as I say, it shows the limits. Here you have a use which is unexplained, which isn't necessarily in respect of particular goods or services, which might be some sort of political statement, but the brand thinks is damaging, and they were unable to do anything about it, other than, as I say, under passing off largely. And this sort of situation has arisen in lots of other scenarios over the years, and we've got a few examples there on the slide. The two or the 3 versions of the BP logo are versions that were done by campaigners after the BP oil spill in the Gulf of Mexico. And there were various competitions run to produce different logos, all of which portrayed BP in a somewhat bad light. Could BP have sued under trademark infringement to stop them? Or even copyright? Well, I don't think it did, but even if it had, there may have been difficulties for similar reasons to the Unilever case. The ESSO example is actually of a successful example of a successful case run by a brand owner, where a campaigner asked that a campaigner changed the ESSO logo so that the 2 S's became $signs, campaigning against various of their practices. ESSO successfully sued in France, and so the logo became censuré, which is why it's there. So in some jurisdictions, in some circumstances, you may be able to stop it. The McDonald's picture on the bottom left is relating to the McLibel matter of some years ago, where a young Keir Starmer, as he was the barrister who represented the pair there, who were accused by McDonald's of libel because of a campaign they ran in respect of various working conditions at McDonald's. That case, although legal actions were brought against them, ultimately became a cause célèbre and perhaps didn't help McDonald's at all, because the campaign became much better known because of it. And then the final 2 examples at the top, 2 tweets. And these are tweets under a brand from the official Twitter handle of those brands by the people within, presumably, the marketing department. The one on the left from Tesco was sent in the context of the horse meat scandal of a few years ago, where it was argued that some Tesco products had horse meat in them, and the social media team decided it would be a good idea to say at the end of the day, it's sleepy time, so we're off to hit the hay. That was seen as a poor taste, or not taking the issue seriously, and perhaps didn't do much good. And the other one on the right is probably a rogue employee of McDonald's who decided to put up this tweet, and presumably without the authorization of McDonald's itself, saying, addressing it Donald Trump, "You're a disgusting excuse for the president, and we would love to have Barack Obama back. Also, you have tiny hands." And that's an illustration of what happens, and has been known to happen in various cases, where disgruntled employees take control of some part of the messaging system and give messages out. And there's one, a famous one recently in the context of Dominic Cummings as well, which people may be aware of. So what do we do about those sorts of threats? And at this point, I'm going to hand over to Michael to tell us, what do we do if you're not an IP lawyer? What are the things available to you?
Thanks, Mark. Well, yeah, following up on the point that there are threats to brands which IP rights cannot prevent or manage, I'm going to turn to reputation management, specifically corporate reputation management. So managing the reputation of a company, i.e. a brand owner. So what really is corporate reputation? Well, it's what people think about your company, including your brand. It's what people think about your products or your services that you provide, what you do to your customers, or how you treat your customers, how you treat your employees, what you might do in the wider world or in the environment. It's really what people think about you or in your company. And of course, that encompasses the brand. Why is it important? Well, again, it's an obvious answer. If you have a bad reputation, then it's much, much harder to do business, to sell your products and your services. It's much harder to retain talent. It's much harder to do business between other companies. And in some cases, it can destroy your business. For example, we've seen in the recent years, we've seen that happen to Cambridge Analytica. But in this day and age, and with the advent of social media and cyber attacks and 24-hour news cycles, there are new threats which require a new approach to protecting corporate reputation and brands. And that really comes from the new threats that are out there. And as I mentioned, social media, employees and customers are now empowered to take to Twitter or other social media platforms to voice their opinions and criticize how companies conduct themselves or how brands operate. Cyber attacks are now an everyday occurrence, where hackers can hack in and steal information and publish it, or companies can suffer catastrophic data leaks, which then results in customers mistrusting those companies and those brands. And again, a 24-hour news cycle means that really there's now more content than ever and more interest than ever in what companies are doing, especially post 2008 companies and how they conduct themselves, and brands and how they conduct themselves, for example, in relation to tax issues or tax avoidance issues, has become a very, very important subject for the media to report on. And if you're attacking a corporate reputation, then that has a potential to obviously damage the brands. The two are inextricably linked. And what I've put on the slide there, the second foray into the animal shots that we had at the beginning, are the key areas of risk that we in the reputation management department have identified that our corporate clients are at risk of. And this comes from advising our clients historically on a whole array of different issues. And we have essentially, from that experience, identified reoccurring areas of risk. And so in addition to media and brands, that's what we're obviously talking about now, we also identify the areas of cyber investigation. So that could be an internal investigation, into the company or an external investigation by a regulator. Product safety, lots of stories in the media about that. People, i.e. what your employees do or don't do, and the fallout from disputes with employees. And lastly, activism, and that can be shareholder activism, that can be campaigners trying to damage your corporate reputation and your brand. And so we work regularly with colleagues in all those different areas of our firm in order to manage the corporate reputation of the clients, depending on what types of risks take place. So moving on to the next slide, just to talk about some of the legal tools that we use in this nebulous nebulous concept of reputation management. The legal tools I've grouped there into three different tranches. So those that there's some overlap, of course, but those that are regularly used by corporates, those that are regularly used by individuals, and then there's IP rights there as well. Now, in relation to corporates, I've put in there the law of defamation. That enables a claimant to seek remedies in relation to a false and defamatory statement which is published about them to a third party. The Defamation Act 2013 has raised the threshold for bringing such claims so that you now have to show not only that a statement is defamatory, but that it causes serious harm. And for a corporate, serious harm means serious financial loss. So the threshold has been raised in that respect, and that's made it harder for companies to bring such claims, but defamation is still a useful tool. Malicious falsehood is another useful tool there, and you have to show that a false statement, not a defamatory statement, but a false statement has been made maliciously, i.e. the person making it knows it's not true or is reckless as to the truth, i.e. they don't really care if it's true or false. And again, you have to show that financial loss has been suffered in most cases, not all cases. And that's commonly used by warring competitors, warring corporate competitors to stop one another trying to make false statements about the other to damage them. Breach of confidence, you'll all be aware of what that is and what that means. And again, companies go to great lengths to protect their confidential information. Switching over to individuals, the law of privacy allows individuals to protect the misuse of their private information. A company doesn't have a right to privacy. It comes from Article 8 of the European Convention of Human Rights, as imposed into the law in this country via the Human Rights Act. And so it's a remedy that an individual has in relation to his or her private information. You need to show that there is a reasonable expectation of privacy, and that reasonable expectation and that right to privacy outweighs any Article 10 rights to freedom of expression to publish or use that information. And there's obviously been a lot of high-profile cases in that very recently. Data protection as well, it applies to individuals. Corporates don't have data protection rights, but the GDPR has codified a lot of the previous rights of individuals there, such as the right to erasure, subject access, the right to object now. Very, very useful for managing individuals' reputations. And you may ask why we're talking about individuals at all, but the reason for that is because a lot of corporates have a lot of prominent individuals who work for them, and so damaging an individual's reputation can a lot of the time have a knock-on effect onto the company's reputation. And so that's why we as reputation management lawyers use individuals' rights to manage corporate rights at the same time. The law of harassment, I won't go into that too much, but that can be used to stop malicious persons or indeed malicious publications. And then we're into the intellectual property rights. Over to you, Mark.
Yes, and to some extent we've already talked about these, but they're the ones which I'm sure lots of people on the call will be very familiar with. Copyright, for certain types of content, and with products, it can be the packaging, the labeling, for example. Trademarks, registration of trademarks, always well worth doing, and can be useful in particular cases. Passing off, as we saw from the Unilever case. All of these may come in at one place or another, and often if you can assert those, you do. But as I say, often really it's more the stuff that Michael's talking about that you need to rely on.
Yeah, and then at the bottom there we've got a list of some of the regulatory codes. So there is the IPSO code, and that's the first one there. And IPSO regulates a lot of media publications. They sign up to IPSO and they have to abide by the code, and the code creates obligations of accuracy, for example, or respecting people's privacy and harassment. So it's another regulatory layer by which to manage reputations. The Ofcom code, that's a code that broadcasters have to abide by, and it contains obligations of things like accuracy again, and treating people fairly who feature in programs. Again, there's a lot of different provisions in there, but it's something that allows you to hold broadcasters to account when they're broadcasting information about you. And lastly, the ASA, the Advertising Standards Agency, and
authority.
Authority, and the codes there. Whoops, the codes there in relation to advertising. So that's a quick rundown of the legal tools. In terms of the direction of travel, I think it's fair to say that because of the new Defamation Act, it's become much harder to bring defamation claims, which you can bring, of course, as an individual as well, but we're talking more about corporate reputation here, especially because you have to show this serious harm, which in a company's case is serious financial loss. And I think it's also fair to say that the privacy rights of individuals have increased, not only via the GDPR, but by a lot of helpful recent cases, particularly in relation to criminal investigations most recently. So moving to the next slide. So reputation management and the three stages. This is really a slide about the approach that we take to managing reputation. There are three stages: preparation, crisis management, and reparation. So what do we typically do at each stage? Well, preparation, we would anticipate together with PR agents, media issues ahead of time before they become crises points, and we would create a protection strategy. We would legally check statements before they're published, or we would anticipate threats and protect reputations of key individuals of companies to avoid any collateral damage. In terms of crisis management, that stage, the second stage, we would apply legal pressure to stop or alter stories before publication. We would stop competitors from maliciously spreading false stories, and we would prevent the publication of private or confidential information. And that's the real kind of crisis stage. It happens very quickly, and there's not a lot of time to make decisions. So obviously, the more preparation you can do, the better. And then lastly, reparation. That's where the crisis has already happened. The publication of broadcast has already taken place. The damage has already happened, and we would try and remove or correct original stories, obtain apologies or clarifications. We might make regulatory complaints if we can't get a good outcome, or even a legal claim if the client feels strongly enough that they want to take that sort of action to obtain the remedies they're entitled to under the law. And it can also involve data subjects and right to be forgotten requests. So yeah, those are the three stages. So I think, Mark, we're going to move on now to some examples.
We are
exciting times.
Here we are. So here we get a chance to see what the audience thinks, which is in some ways a lot more interesting, I'm sure, than either of us. So we're going to run through a series of examples. I'm going to pose them to you. We're going to let the audience vote on the various options, and then you're going to tell us what you think the answer is. So the first one is about a fashion brand. and it's a topical example, COVID-19. Because of that, there's been speculation about redundancies, furloughs, and pay cuts among the employees, but also rumours that the senior staff, meanwhile, are feathering their own nests, and they're not going to suffer any cuts or salary reductions at all. And in fact, the real truth is that measures have been put right across the board, including 20% salary cut for senior staff, and a factory is now producing PPE. So there's a good news story there from the company. Press release is prepared, but you receive an email from the newspaper saying it's going to publish, well, it doesn't say it's false and damaging and defamatory, but they are false, damaging and defamatory allegations that you're profiteering and treating your staff poorly. What should you do, Michael?
So option A is to apply for an urgent interim injunction to stop the story. Option B is do nothing, and option C is engage with the newspaper to explain the true position. So if everyone would please vote.
Okay, votes coming in. That's quite quick. Okay. Okay, look at that.
Okay, that's good. So 7% there, apply for an urgent injunction to stop the story. 24%
engaging the newspaper, and there's no one saying do nothing.
No one's saying do nothing. Okay, so apply for an urgent injunction. Well, that's not available as a matter of law in most cases.
In the UK.
In the UK, certainly not in America. But in the UK, the law, case of Barnard and Perryman, says that you cannot apply for an interim injunction pre-publication unless very, very specific circumstances are met. So in most cases, in almost all cases, you can't do that. It's not an option as a matter of law. So you're left with do nothing, which people rightly have not gone for, and I think the reason for that is because in the current climate, which to do with COVID-19, this is too much of a damaging story to just do nothing about, and it is really the case that if you get things wrong in this current environment, your customers are going to remember that for a long time, and that might cause very, very long-lasting damage. So that's why a lot of companies are rightfully defending their reputation in this environment where false allegations are made, because it's just too much of a risk. So you're left with C, engage with the newspaper to explain the true story, the true position. This is exactly what you should be doing. The newspaper have got it wrong here. So you need to explain to them that they won't be able to justify the allegations if they publish. And you also need to explain to them that there's no public interest in publishing this story because it's wrong. And this is an example where explaining what's happening to the newspaper and getting your press release out as quickly as possible, you might be able to turn this story into a good news story about what you're doing, and essentially use it as a platform to show the good work that you're doing and how you're helping your employees and helping with the production of PPE.
Michael, one thing I'm wondering about that is, it seems as a non-expert these days that newspapers are more careful about checking stories with the person they're writing about before they just go ahead and publish. And this has been an example of that, which gives you the opportunity to try to influence the story. Is that the case across the board, that you're more likely to hear from them first?
I think it depends on what the allegations are, and it depends on the newspaper. But the reason why newspapers come to people for comments generally is that if they do that and they then go ahead and publish, they may be able to rely on what's called the public interest defence, and that is where that is where they're able to say, well, I went for comment, I tried to act reasonably and verify the allegations I wanted to publish, and the information and comment I got back didn't dissuade me from going ahead. Therefore, I still reasonably believed that publishing these allegations within the public interest. And so it's a kind of, it's another defense you can use, that newspapers use a lot of the time, where they feel that they've looked into something, they still passionately believe that it's in the public interest to report it, and they've acted responsibly. and they go ahead. And so in those circumstances, they're entitled to rely on that defence.
Yeah. So I suppose the option is you're more likely than you used to be to hear from the paper first and to get the chance to put your side, but you won't always do it, I guess. Yeah. Okay.
I think that's right. Sometimes things fall through the net, especially if the newspaper doesn't think it's defamatory, but we'll come on to that later.
Okay. So the second example is someone claiming to be a whistleblower. And a whistleblower has a particular status in various laws that they enjoy some protection from disclosing confidential information. So the whistleblower here is called Mrs. Markle. She's been dismissed from the client for gross misconduct. She issues a claim in the UK tribunal for unfair dismissal, but it hasn't become public yet. That's what's going on. At the same time, she's contacted various journalists alleging and claiming she's a whistleblower, that making out various allegations against the company and private information belonging to a co-worker. She's also created a spoof website using the trademark of the company and its logo for an online petition with false allegations in there about the CEO. And a newspaper's contacted you for comment. So 3 options again, Michael.
So option A is to engage with the newspaper to stop the story. Option B is to engage with the website host to shut down the site using media or IP law. And C is to settle with Mrs. Markle ASAP with an NDA.
Okay, so please do vote, and we'll come back with the answers in half a minute. Okay, well, people can keep voting, but let's see where we've got to now.
Option A, engage with the newspaper to stop the story. B, engage with the website host to shut. Yeah, okay, so most people have gone for B. Then it's A, and then it's C. Mark, do you want to talk about B?
Yes, so there are options available under IP law if your trademark is being misused by a hosted website. You can try to, assuming you can't get the site itself to change things, you can go after the host and you can bring it to their attention and explain what your rights are. And although the host will often have a defence at the moment under EU law and applicable law in other countries, that they're unaware of what was going on and that they're a mere host, as soon as they're put on notice with enough specificity, then they risk themselves becoming liable, so they may well take the content down. So that may be applicable. The other thing you might be able to do, depending upon how Mrs. Markle set this up, there may have been a domain name, and you can go after the domain name. There are various processes, non-court processes for doing that, but they can take a few weeks. And I've certainly had experience, though, of contacting the people running domain names where there's been an obvious fraud going on, to say this domain name is being used for fraud and you really need help us take it down immediately, and had quite good results. So if it's really bad, sometimes you can get much quicker help.
Yeah, I think all I would add to that is that we've obviously put the option there is to engage with the website host rather than Mrs. Markle, who is presumably the website operator and the person who has set it up. And the reason for that is that if you write to Mrs. Markle in this situation, she's very likely just to publish your letter and try and make you look even worse in her eyes. I think the point, just to the slight thing to just mention about that, is that sometimes in these types of situations you get a website which is being run by a campaign group. So we've dealt with a few cases where campaign groups have set up petitions to defame CEOs or what have you. In that situation, you might want to think twice about writing to the host, because it's likely that the host might pass the letter on again to the campaign group, and then of course that can potentially be another own goal. There's obviously a chain here. There's what's happening on the ground, then there's the website, and then there's a news story. And so typically in these types of situations, we may advise the client to kind of ignore what's going on beneath the surface and just deal with the newspaper, which is option A. So just moving on to that option there, I think it's worth just noting that in the example here, she has issued proceedings for unfair dismissal, but there's no public hearing yet. Now, the reason why that's significant is because if proceedings are in public, then a newspaper is able to fairly and accurately report on those proceedings and repeat all the defamatory allegations that may be contained within them under the protection of statutory qualified privilege, which allows a newspaper to essentially regurgitate what is being alleged against it in the claim. Now here, there is no public hearing yet, and so the risk is really on the newspaper, because if they want to repeat these allegations, they're not going to have the defence of statutory qualified privilege. They're going to have to rely on other defences, such as truth, which means they're going to have to prove the allegations are true, or they're going to have to rely on the public interest defence, in which case they're going to have to reasonably believe that publishing these allegations is in the public interest. So this is your chance to engage with the newspaper and explain why Mrs. Markle's allegations are all false, if indeed they are, and to try and stop the story. And if you can stop or alter the story, then that may be enough for you, and you may be able to leave the website alone to deal with another day. The option C, settle with Mrs. Markle ASAP with an NDA. I think, that's always an option, but obviously there's been a lot of controversy around NDAs over the last couple of years, with Equality Commission studies, government saying they're going to change the law, changes to the SRA and Law Society guidance, and of course the Philip Green case and the Linklaters case, which all relates to enforcing NDAs, where someone is claiming, be it a newspaper or the person subject to the NDA, that they have a story to tell. And so, although the courts have very much favoured the public policy reasons of upholding NDAs, sometimes, or some people's views, that they may not be worth the paper they're written on, if you're not going to follow through and enforce it. And sometimes the worry about doing that is that following through and enforcing it may mean that you're causing more publicity, as is what happened to Mr. Green, who was outed with parliamentary privilege. So it can be a double-edged sword, and we would advise that you think carefully about doing that and make sure that the NDA is properly drafted with the right caveats and the right things in place, because otherwise it's going to be even harder to enforce.
Great, thanks. So we've got time, I guess, for maybe 2, maybe 3 more examples. So the next one is this is about a comedian. You act for a client called Nice Smells, and your client writes, you don't do it obviously, but your client writes to a small family business for trademark infringement. And this attracts the attention of a comedian who makes some mileage out of it, changes his name to Nice Smell, goes on social media talking about it, does a TV interview, he has a TV weekly show himself, and he's going to make that weekly show next week all about you and what you've done in respect of this small family business. 5 options here. What are those, and what should we do before? Or let's hear what people vote on.
So option A is send Kevin Hilarious a cease and desist letter. Option B is send Channel X a letter addressing the allegations. Option C is provide a statement for broadcasting Kevin's show. Option D is release a statement apologising, and E is doing nothing but review your enforcement policies. Please vote.
What do you think?
So most people have gone for B, which is send Channel X a letter addressing the allegations. Yes, I think that's right. I think these are damaging allegations. Sending Kevin Hilarious a cease and desist letter, that's option A, only 4% there. I think sending him a cease and desist letter is probably going to do more harm than good. He was probably going to publish the letter, and it's not going to dissuade him from the crusade that he's on. Whereas sending Channel X a letter, they have obligations under the Ofcom code, whereas Kevin doesn't. They're at risk of being sued. Kevin may not care, he may be indemnified. And so really that's the right route there to apply pressure and to address the allegations. Option C, which is closely behind B, 9% there. Provide a statement for broadcasting Kevin's show. Yeah, I think that's the right thing to do here, because if you don't do that, there's going to be nothing from you, and the segment is going to end with we reached out, but no one was available for comment, or no one wants to comment, and that's going to look like you don't care. Release a statement apologising. That's got the least votes there. That may or may not be right. It depends upon the position you want to take, but it probably will. It could again cause a backlash. And 3% there. E, do nothing but review your enforcement policies. I'm not sure I agree with the do nothing part, but Mark, do you want to talk about reviewing enforcement policies?
Yes, and I think it, to some extent, it goes hand in hand with the cease and desist thing. There's sometimes you do need to go after people who are small and potentially problematic because they may grow big or it's causing confusion, and so there's no reason why you shouldn't. But I think there's an art to it, and there, as people will be familiar in various situations, amusing versions or amusing types of cease and desist letters have been prepared by brands to send, and that can be the appropriate response, or something which, if you think there's a good chance it's going to be picked up, you try and make it seem human at least, and you don't try and look like a huge David and Goliath bully. So I think you may review your enforcement policies about going after smaller people, but you might actually decide we just need to approach this slightly differently in future. Okay.
So I think we've got about 10 minutes left.
Oh, sorry, part 2 I just jumped over.
Yeah,
this one we asked a couple of people earlier, so we've actually got some results for this one already. So Nice Smells Part 2. After the broadcast, it's picked up with media. An online troll obtains private selfies of the CEO and his children in the villa on holiday and puts them on social media. And newspapers contacted you about the photographs. What do you do? It's all got nastier.
Yeah, so do you engage with the newspaper to stop the story? Do you engage with Twitter to have the tweets, photos removed? Or do you do nothing and hope that the storm passes? So what are the results for this one? Okay, so we've got A is 13% there, engaged with newspapers to stop the story. B, 11% engaged with Twitter to have the tweets and photos removed. And lowest results there for C, do nothing but hope the storm passes. I think the point here is that you're talking about private information here. The CEO is on holiday in a private villa, photographs of him on holiday and photographs of his children. Children have elevated rights to privacy under English law. So this is quite squarely private information with not really anything relevant to the issue at hand. I think you've got a good shout there if the newspaper won't back down to apply for a privacy injunction to prevent publication altogether. So you'd be threatening at least to apply because I can't see any public interest or any public interest that would outweigh their privacy rights, particularly not the rights of the children. In terms of engagement with Twitter, the useful point here is that they're selfies, so that the CEO and or his children own the copyright. And so it's much easier to have content removed if you're utilizing IP rights against Californian-based or US-based social media platforms, because they simply have high regard for intellectual property rights rather than privacy and reputation rights, particularly as they don't have a law of privacy in the States. And do nothing but hope the storm passes. Well, you could do that, but it's quite a serious invasion of privacy here, and it's going to go in a kind of David and Goliath story, which could keep things running and be equally as damaging. Mark, I don't know if you've got any comments.
No, I think, yeah, this one you just want it taken down and got rid of, and I would have thought you should be in a fairly strong position to do that. And if anything, it probably helps to frighten off Kevin doing anything in the future. So it may be double-edged. One last example then, the cyber breach, which unfortunately is becoming more and more common. Your client Bulletproof has a cyber attack against it, and an unknown hacker exfiltrates a large amount of valuable IP and confidential information, but no personal data, so no privacy stuff. Then tries to blackmail you, demanding a substantial amount of Bitcoin. You don't pay, and then it posts on the information online. And a trade news site approaches you for comment about allegations that customer data has been leaked, which are inaccurate. 5 options here. Several of them may be right.
So A, apply for an injunction to obtain an order against the hacker's misuse. B, send cease and desist letters to take down the leaked information. C, engage with newspapers to stop the story. D, engage with the newspapers, dampen the story and put your side of it across. And E, call the police. Please vote. Okay, so good. So most people have gone for E, call the police. Some people have said apply for an injunction. A couple more people have said send cease and desist letters to get the leaked information taken down. The least number of people said engage with the newspaper to stop the story, which is quite surprising. And there's more people who have said engage with the newspaper to dampen the story. So I think just a couple of points here. I don't think any of these are necessarily wrong. I think they're all right. The comment that we would make is that in these types of cases, you can apply for an injunction against persons unknown, the hacker, and you can do that to then use that order to have information taken down from websites where the information is posted after you don't pay the blackmail ransom. You can use that order to get information taken down a lot quicker than you can via a cease and desist letter. So it's a question of timing, although there's obviously a much larger cost involved in obtaining an injunction. You can also obtain these types of injunctions under the protection of anonymity, because a lot of companies obviously don't want to litigate because they feel that doing so will put everything in the public domain, and they just want to deal with it under the radar. Why shouldn't they if your company's being blackmailed? Engage with the newspaper to stop the story. Well, I think you would be looking to do that on the basis that these allegations are inaccurate. They're talking about leaked customer data, and no customer data has been leaked. It's obviously very damaging if such a story is published, because your customers might think that you don't securely hold their data and they might not want to do business with you anymore. D, engage with the newspaper to dampen the story. Well, you could go for that angle instead and try and turn it into a kind of PR piece to say, yes, this has happened, but we're taking it very seriously. And E, call the police. In our experience, a lot of police investigations often run in parallel to the civil side of things, but obviously the police aren't going to be able to have information taken down off the net, and they're not going to be able to stop stories in newspapers either. So again, limited as to what they can do, and obviously dealing with the police can sometimes take a lot longer.
Yeah, and you can lose control of the process. And one thing I was just going to say, just about the getting an injunction or whatever to take the information down, the difficulty you sometimes find is that although I think a court will have a lot of sympathy with this, the claimant in this fact pattern, if the material is said to be confidential, but it's been published online, at some point it loses confidentiality, and a court isn't going to enforce it. So speed's of the essence, really. And don't delay.
Have we got time for one more?
I'm not sure we have, because I think we're slightly at the end of our time. So if you want to, I'll tell you what, let's put one up and you just rattle through the answers without us doing the survey. But then I think we should let people go.
Okay. So the errant celebrity endorser. So your client Immaculate, which produces women's health products, wants to increase its brand profile in the sports world and enters into an agreement with the sports star Claire Lightning. An advertising campaign is launched and everything seems to be going well. You are then contacted by a newspaper for comment about allegations that Claire's been having an affair with the new CEO of Immaculate, has been photographed taking Class A drugs in a high-end nightclub and reportedly made his historical racist comments on social media. Should you A, terminate her sponsorship agreement, make no comments, B, terminate her sponsorship agreement but release a statement, C, sue Claire for bringing the company into disrepute, or D, advise the CEO and Claire to hire lawyers to stop the story? Well, this, again, is an interesting one. I think it really reflects on the fact that if you're going to enter into an endorsement contract with a celebrity, you need to have provisions in there that allow you to terminate if they bring your company into disrepute. You might consider some kind of reverse morality clauses. You might have clawback provisions in your agreement in the event that you've already paid them a load of money and you want it back. I think in this instance, you would be terminating and probably releasing a statement to try and distance yourself from this individual as much as you could, certainly in relation to the historic racist comments. Would you sue Claire for bringing the company into disrepute? You may threaten to do so, or at least try and come to some kind of settlement to extricate yourself from the agreement, because presumably you're obliged to pay a lot more money later on down the line. So you'd want to think about that, maybe use it as a negotiation tool. And D, would you advise the CEO and Claire to hire lawyers to stop the story? Well, there's an interesting point here about conflicts, and often when you are trying to defend a company's reputation via also enforcing rights for individuals, a conflict can arise between employer or CEO and the company. And so, yes, you would definitely be advising the CEO to go and seek independent legal advice. Two lawyers are better than one, but the conflict point is the main reason. And the reason for doing that, of course, is that the CEO has privacy rights here, as does Claire. The public interest in publishing details about an affair are much lower than the public interest in publishing photographs of a sports celebrity taking Class A drugs or making racist comments. So it may be that you can extricate the CEO if you enforce his privacy rights in relation to this story. That's always a possibility.
Right. Michael, thank you very much. And
thank you, Mark.
Thank you very much to our audience for sticking with us. That brings us to the end. And if any of the issues which have arisen give rise to more questions, then please do get in touch with us. We're delighted to answer them separately. And we look forward to seeing you on the next one of these. Thanks very much.
Thank you.